Justice Gorsuch?
I just want to explore, just for a brief minute, I hope, your scintilla of conclusive and preclusive power theory. You agree, I assume, the president is vested with all the executive power.
Yes.
You agree that he has a duty to faithfully execute all the laws.
Yes.
Civil and criminal.
We agree that the Constitution imposes on the president a duty to faithfully execute the laws.
All
absolutely.
the laws.
Well,
some laws he doesn't have to? That'd be news to our friends across the street.
The take care clause is a duty, and it is also a power, but the text of the clause does not provide that the president must have at-will presidential.
I didn't ask that. This is, does he have a duty to faithfully execute all the laws?
We know from
yes or no?
I would say no in the sense
no.
in the sense that let me. There's two different questions, and I want to make sure that I'm answering the question.
The question is, does the president have a duty to faithfully execute all the laws? The answer is no. Why?
So he can't break the law for sure. For sure. Does he have to be vested with statutory authority to actually directly enforce, or to exercise?
I'm not asking whether he has to bring the indictment. I'm asking whether he has a duty to faithfully execute the laws.
I think the president does not, under both history and tradition, have to have plenary power of supervision. But in the case of the FTC, he does have some power of supervision, including if there's a demonstrable, palpable violation of law, the president could absolutely fire a commissioner of the FTC under the plain language of the statute.
So the answer is no, I guess. But you say that he has to have direct supervision and removal authority for someone who has conclusive and exclusive authority to bring criminal prosecutions, right?
That is our understanding of this court's decision in Trump v. United States.
That's your understanding?
Yes.
But not civil?
That's right. And to go back to earlier.
And then just to be clear, so that means if the government wants to bring a misdemeanor, that person has to be reportable to the president. But if the government wants to bring ruinous fines and penalties and injunctions, that person doesn't.
I don't know the scope of this court's holding in Trump v. United States.
I'm asking you for your theory, because it's a very interesting theory. You're building off of two words from Trump versus United States and putting a gloss on it that I'm not familiar with. I'd understood the executive power, and he has conclusive and preclusive authority of that. But this line, I don't know where it comes from. And I'm wondering, I'll be honest, I'll put my cards on the table. Maybe it's a recognition that Humphrey's executor was poorly reasoned, and that there is no such thing in our constitutional order as a fourth branch of government that's quasi-judicial and quasi-legislative. Maybe you're trying to backfill it with a better new theory that itself recognizes that we've got a problem.
The theory that we are referring to, Justice Gorsuch, as we understand it, is not just based on this court's recent decision in Trump v. United States. It goes all the way back to Marbury v. Madison. And Marbury does not use the term conclusive and preclusive, but it absolutely says—
And neither does Humphrey's. It uses quasi-things.
It talks about the distinction between authorities that are vested in the president and the president's powers in the constitutional sense, and executive power in the constitutional sense. And it actually cites Marbury v. Madison for that.
Oh, sure, I would hope it would.
For that proposition.
Yeah.
And Marbury itself distinguishes in the context of removability of federal offices.
I guess I'm just wondering, are we going to get, if we take your theory to backfill Humphrey's and go down this road, how are we supposed to decide which powers are exclusive and for your purposes, as you understand it, not as I understand it from Trump v. United States, but as you understand it, what powers are going to fall in and what going to fall out? Are we going to have just as much litigation over that as anything else we might do in this case?
I don't think so. We've had this modern era of traditional independent agencies for a long time. We haven't had any precedent ever striking them down, and this court has not been, as far as I know, overwhelmed with difficult questions of line drawing. In fact, from 1935 to 2025, we had pretty much unanimity among courts that traditional independent agencies are fine. To go back to
you haven't had a lot of litigation over Humphrey's and its limits and its boundaries, and I mean, seal of law, you invoke it as a great decision. We've had a lot of litigation.
We do invoke seal of law as a great decision.
We're always going to have litigation over the separation of powers, aren't we?
There will always be litigation, absolutely. But the point is that this court's precedents affirming Congress's authority to work with presidents to create traditional independent agencies has not generated any significant problems, still less insurmountable problems.
Thank you.